first like to address, Your Honor, the issue that this case was an execution. If you recall, reports that had been marked into evidence regarding the condition of the gun that was found in the speaker at 39 James Street. That was a gun with a broken clip that was full of cotton balls in order for it to fire one bullet at a time. Scarcely the kind of gun that a person would take to an execution. I object to the category to the Commonwealth categorizing this case as an execution. There was plenty of evidence in the case regarding chase, regarding a chase with weapons, regarding a chase on foot after Mr. Kong's car, hardly looking for a blood to kill. I think I object to the prosecution's characterization of the evidence in that way. Regarding remorse or bad feelings, the court recalls my very first words to the jury was that everyone in this courtroom, and when I spoke of my client, for my client, to the jurors, recognizing that the death of a young person on any city street is a disturbing and upsetting event. Your Honor knows that there are situations such as legal reasons why a person doesn't do certain things, but certainly has a spokesperson in his attorney. Regarding any smirking at the family, I would find that really truly shocking. My client, throughout this proceedings, you've observed him, and the court has observed him to be a very respectful person, someone who has taken this case seriously. Not anyone that would turn and smirk at family members who were not on the streets we're not on Branch Street, on Middlesex Street, since the ones who were there were sequestered and not present to see any gestures or expressions that my client might have made. So I don't think that happened, and I hope the court will not take that into consideration in sentencing. Regarding taking responsibility for the case here, for his actions, I think my client has taken responsibility. He gave a statement to the police where he accepted and told them that he had fired the firearm, but then the mitigating circumstances were that he believed his life was in danger when he fired the firearm. It wasn't if you feel in your emotions, in your heart and your soul that you're being chased and your life is in danger, certainly that is the time and place when you express it. And I think he's done that not only to the police, but also has taken the stand and testified and admitted to this court what his actions were, what he believes the reasons were for him to act the way he acted on Branch Street. I was handed something from I guess this is the FBI, I'm not quite sure what that exactly, regarding a criminal record. I wanted to note to the court that these are juvenile records. From not having had this to check with the authorities in California, I don't have certified copy of the convictions to bring to the court, but the first one having to do with the car, as you can see, he was released to his parents. Could have been a very serious charge, or nor did the authorities think that he had done anything wrong when he's released to his parents. As far as the robbery is concerned, my understanding from my client is that that case was dismissed. Although he was held at juvenile hall pending the disposition of the case, but the disposition was an outright dismissal The third having to do with the bench warrant and failure to appear, those are traffic offenses. So that, when I said in my memorandum that my client has a scant criminal record, if you look at his adult record, we have 2 convictions for minor drug offenses, one being marijuana, possession of marijuana, one being a possession of cocaine. Possession, not possession with intent, both cases were quaffed, and the disposition time on the more recent case, the quaff was for, I believe, a year, and during that year, he had left the jurisdiction to go to North Carolina. Hence, his probation was failure to appear was to his probation officer. I asked the court simply that the gun charge be run concurrently with the statutory sentence in murder. I have attached a number of exhibits in my memorandum for the court's consideration. One, correspondence from Medtronics showing that my client was working the second shift until 2003, December 2003. Certainly covering a period of time, and Detective Bergeron testified to having seen him walking the streets. And I've also attached a copy of the Facebook page.
All right, counsel, I'm not going to consider that on sentencing. It's not appropriate.
So do you want me not to talk of it? Is that
do not address it, and I'm not going to consider anything else that is in the sentencing memorandum. We're not retrying the case here. This is sentencing. If you have issues, you can address them on appeal. But I'll hear from you about anything else relevant to the issue of sentence.
Well, I've addressed his employment. I've addressed his position regarding trial, how the evidence came in. I've also, although I'm not retrying the case or trying to discuss appellate issues at this point, but I think it's relevant to this court when the issues regarding the identification of Mr. Kung and the extensive coverage of the Lowell Sun and the exposure of my client's picture and array of photograph right on their website for the world to see, thereby influencing witnesses who testified in this case. I think perhaps Your Honor may not wish to take that into consideration at sentencing, and that's entirely up to this court. However, I think those are relevant points that certainly should become part of the sentencing memo if the court wants to hear mitigating circumstances in order to take everything into consideration in sentencing, not one side. I asked the court to sentencing to whatever statutory sentence the court must apply. Concurrent with that sentence, a sentence for the firearm, whatever the court wishes to impose on the carrying of the firearm. It's just that sentence run concurrently with the second-degree murder, and that we waive any victim witness fees in this case. Thank you.